When one company proposes to take over another company, the target company's board of directors will frequently hire an independent third party to conduct some analysis and see if the price that's being offered by the buying firm is fair. Now, fair to whom? We're typically talking about the shareholders of the target company. Okay, so this is going to be called a fairness opinion, and it's typically issued by an investment bank or a company that specializes in these types of valuations. So they're going to say, okay, look, Company P has offered to acquire Company T, and so Company T, their board says, well, you know what, they've offered us $40 billion. Well, let's hire this other company. Okay, let's hire this company F, and then F is going to issue this fairness opinion. They're going to do some analysis and say, okay, yeah, this $40 billion that's being offered to the shareholders of T, yeah, that seems like a fair price given the analysis that we did. Now, the fairness opinion, so ultimately it's just a letter. It's just a letter saying whether the price, the terms of the deal are fair or not. But it's not saying whether the deal is a good idea. It's not saying, yes, you should go for this. This is going to be a great merger, and 10 years from now, everybody's going to be happy. It's not telling the target shareholders, yes, you should vote for this or anything like that. Ultimately, it's just going to say, look, we've done some analysis, and yes, we believe that this price is fair. Now, I'll show you an example from Morgan Stanley, and you'll see exactly what I'm talking about. So why would the board of directors of the target company do this? Ultimately, it comes down to trying to shield themselves from legal liability. Okay, they want to reduce the chance of a lawsuit. In 1985, there was this legal case from the Delaware Supreme Court that basically said that the board of directors, the members of the board of directors, can be held personally liable if they don't make informed decisions. Because remember, they're there to really safeguard the interests of the shareholders of the company, because the shareholders are the true owners of the firm. So if there is an offer, so let's say there's one company offers $40 billion to acquire the target. Let's say that is the only offer that is made to for this target. And so if the board doesn't hire some kind of expert or someone like that to come in and say, hey, is this a good price? Then later shareholders could say, you know what, the board should have done more. You should have tried to solicit other bids from other companies, or maybe you should have tried to get more than $40 billion. You really weren't doing a good job, making sure our interests were protected. So the board is going to say, well, look, we hired this expert. We hired this outside company. That's their job, is to perform this fairness opinion. They're experts at that. They looked at the financial terms of this deal, the terms of the consideration that was being offered, and so forth. And so the board can say, look, hey, we have no personal liability here. So this is really about reducing risk in terms of a lawsuit. Now, I said we're going to give you an example. So Morgan Stanley, they're an investment bank, and I pulled up, basically I went to a filing with the SEC where they had issued a fairness opinion with two pharmaceutical companies that merged. You had the company Merck, they acquired Schering Plough. Okay, so when they acquired Schering Plough, they hired, basically Morgan Stanley was hired. Okay, and you see that for the board of directors, we change colors here. So the board of directors of Schering Plough, they've got Morgan Stanley writing them this fairness opinion. Okay, so Morgan Stanley, this is the company that is conducting the analysis that will lead to them issuing the fairness opinion. Okay, but they're saying, hey, look, it's to the board of directors of Schering Plough. So if the shareholders at Schering Plough aren't happy with what they're being offered, they can't say, well, look, the board didn't even see that we're getting a good price or anything like that. So that's why this is addressed to the board of directors of Schering Plough. Now we see we got the two different companies that are doing the merger here. We got some detail here. This is all like details of the merger. Now the fairness opinion is a few pages longer actually than this, and I'm going to put a link in the description section to the document so you can look at the entire fairness opinion if you'd like to do so. But basically at this point here that I didn't paste in, we got details of Morgan Stanley says, look, these are the things that we did. We did X, we did Y, we did Z. We didn't consider this. We took this to be a valid assumption that you gave us, and so forth. And then at the end is where you get the actual opinion. So they say, based on and subject to the foregoing, we are of the opinion that the consideration to be received, so that's what's being paid to the holders of shares of the target company, is fair. So, and again, it's from the point of view of the holders of share of the target company. So Schering Plough, their shareholders, what they are being offered from Merck, Morgan Stanley saying, based on our analysis, yeah, that's a fair price.